And our next case is Ronald Thomson et al. Versus R&R Conservation LLC et al. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
I'd like to reserve 3 minutes, Your Honor.
All right, the court will note that. I will be keeping time up here, but you also see over your left is the clock. You are the first clock. You're the top button there. If you would look at that, when it gets to 3 minutes, that's when your time is up. We'll be counting down from 15. If you go over that time frame, certainly just come off your rebuttal time at that point. I'll try to give you a warning when you get to 1 minute. Counsel will try to do the same to you as you're presenting your argument.
Thank you, Judge. Thank you, Your Honor.
You do record the arguments here visually and audio, so if you would, stay behind the podium so that you can be seen by the video, and then speak loud enough so that we can hear you. I don't think it really applied in this case, but if you had a child, a minor, or a victim, please use some form of initial rather than the actual name of a child, minor, or victim. With that, we read your briefs and are ready to proceed whenever.
Good morning. May it please the Court. Matthew O'Nest on behalf of the appellants in this case. Your Honors, the trial court did what the Supreme Court of Ohio has refused to do on 2 different occasions, and that is create a bright line rule for courts to test what is a reasonable due diligence search under RC 5301.56. There's been many cases over the years under the statute. We refer to it as the dormant mineral statute. It's a statutory abandonment procedure where a mineral severed from the surface ownership can be reunited through a statutory procedure. There is a notice provision within there that requires the surface owner to provide certified mail notice to the holders, and if they are unlocatable, and it appears from the outset that they are unlocatable, that surface owner may proceed to publication notice. Here, though, the 2 principal cases that we're talking about from the Supreme Court, I'll refer to as Garrity and Fonzie. Both those cases say that each abandonment and its due diligence, so the search for that record holder, the record holder's address, or a holder, so the heirs, let's say, for the holder, that each of those cases are taken on their own facts. There's no one size fits all. But here, the trial court created a one size fits all. And what the trial court did here is it said, if you as a surface owner have knowledge that that record holder lived in a county other than where the property is, and you don't search for that record holder's address or their heirs, in all cases, that's unreasonable. The trial court relied on that fact alone. Because in our case, what we have here is the properties in Harrison County, the record holders lived in Summit County at that time. So within the chain of title as located during the search for the record holder, or their holders, so it would be their heirs, there is an address located in Summit County. Certified mail was attempted at that Summit County address, as well as by publication, so both were done. But in here, the trial court says, because the surface owner's title company and their attorneys did not actually do a search in Summit County, they relied upon what they found in Harrison County, attempted certified mail. Because you didn't search it, that means it is unreasonable. It does not matter what would happen if you did conduct that search. And we don't believe the trial court was correct in saying that the Supreme Court has said that bright line rule applies. It doesn't matter what that other search in that other county would happen. And that's where we think that this case is unique. Because in here, the question is, what if the evidence at the trial court shows that if the surface owner had done that search in that other county, the same address, they would be left with where they sent the certified mail, and that they would have that information. They would get to the exact same point. Certified mail at the last known address of record, and service by publication. And so our position is that the trial court erred because the trial court did not look to the evidence in the record as to what was actually in or potentially in Summit County at the time.
I'm a little confused because this was brought under summary judgment proceedings.
Correct.
If you just had a regular trial on whether it was abandoned or not, and you're looking at the issue of due diligence, would the trial court, would that be a discretionary decision whether somebody exercised due diligence?
So, I don't know if it would be discretionary in that sense. I think it would be subject to the standard of summary judgment. So,
that's what I'm saying. I was taking it out of the summary judgment context.
Oh, just in general?
Yeah, because that's what I said. I'm a little confused here because this is summary judgment. Okay, so obviously we know we review summary judgment de novo, but yet the court is making the determination as to what constitutes due diligence under a summary judgment. And as you just said, the facts are extremely important. So it just seems like there's a little inconsistency there, and I'm trying to figure out what our review would be.
I certainly think it's de novo, and so the issue comes down to this, is that on summary judgment, the facts aren't really in dispute mostly. Now, in my reply brief, I bring up a number of documents that the appellees raised in their appellate brief, which are not in the record. There's a variety of documents. They say, well, there's this lease here. None of that's in the record. It was not presented below. What we know here on summary judgment is there was no search done of Summit County. There was not a separate search done of Summit County. That's undisputed. We also know that the appellees admitted in request for admissions that if you went to the reporter's office in the probate court in Summit County, you would not locate a different address for Martha Thomson, that was the record holder at the time, or the identity of her heirs or an estate. There was none of that. So if they had done the search, according to the appellee's admissions, you would not have found anything in either of those locations. So I think it is discretionary.
You know, they dispute that last point. They dispute the point that you wouldn't have known her heirs because if you had gone to the probate court and saw husband's estate, you would have seen that she was the sole parent of the surviving two children. So assuming you went to the death record, the person and saw that she passed, you would know her only two intestate heirs were her two children. So you would have, it seemed to me they're arguing that's not, they may have said that in their discovery responses, but that's not true. If you look at Summit County records, you would have at least been put on notice that these two children were her heirs. And at least one of that, and there were addresses listed from them as of that estate.
Okay. So the issue with that is, one, admissions aside, I think the admissions are still what they are. They didn't ever withdraw them. They didn't file anything with trial court on that. But if you go to the husband's, so the father's, let's say father's estate, everything went to the mother. So it doesn't matter at that point because she's the record holder. There's nothing more in either the probate court or the recorder's office saying that she's not still the alive record holder. And there was an address for her. Certified mail was attempted at that address. So
there is, because she died intestate, there is no probate court, no estate file, you're saying?
well, there wasn't an estate file because they decided not to file an estate.
Well, that's what I'm saying.
Correct.
She died intestate. It was under, it could have been under a certain amount. We don't know. Or maybe there was evidence of that. I don't know. But the point is there's no probate proceeding.
There's no probate proceeding saying that she's dead. There's nothing in the recorder's office saying that she's dead. And I think what we get down to, though, is if you look at Garrett...
Why would your search be limited to Martha? It's undisputed that Alec died first, but did K&R know that when they initiated the processes to have the mineral rights deemed abandoned?
That Alec had died?
Yeah, first.
Well, I believe they had searched and located that Martha was the only one alive. She was the only one because it was estates filed for Alec.
Well, they had searched some, either did or didn't search some kind of record. If
No.
they didn't search some kind of records, it would seem they wouldn't know any of that. So if they did some search, that's how they would have found it out.
Correct.
That's why I guess I'm confused.
Correct.
If you're telling me they knew Alec had passed.
They did a full search in Harrison County of all.
Right.
They did not search Summit County. That's correct. So they wouldn't have known that he had passed away. That's accurate. So based upon the Harrison County record, they gave service by certified mail to both him and Martha by certified mail and published against them. The point of the estate of Alec Thomson was brought into, okay, what does this mean? So the trial court says if you don't leave Harrison County, it's de facto unreasonable, it doesn't matter. It doesn't matter what's in Summit County. We don't believe that's accurate. We believe the Supreme Court has said there is no bright line, it's due diligence case by case. So then we get into what does Summit County show? It shows Alec Thomson died. Absolutely there's an estate. Everything goes to Martha. There's nothing further to do. So the same thing would have happened. There would have been certified mail given to Martha Thomson at the last known address in Summit County and publication.
So
That
the
was
kind of
attempted.
record shows that Martha passed because of the death certificate for her, she passed at 22. Is that accurate? She died in Summit County, so there is a death certificate somewhere.
There is a death certificate somewhere, correct.
In Summit County.
Well, yes,
I mean, I said somewhere, but there's a death certificate in Summit County.
In Summit County, yes.
Somewhere we know it's there.
okay. Now, during discovery, the plaintiffs in this case, the appellees in this case, did not point and say that that death certificate meant anything. They referred to some other documents that have nothing to do with this property and don't list the heirs. The death certificate that's in the record doesn't list the heirs. It doesn't say where her estate went or any of that. But if you look at Garrity and Fonzie, paragraph 24 in Garrity, it talks about the language of RC 5301.56E1, this is the notice, does not mandate an attempt at service by certified mail when it is apparent that such service cannot be completed. It goes on to say, rather, by its plain language, the statute operates any time service of notice by certified mail cannot be completed on any holder. This includes circumstances in which a holder's identity or address is unknown. So what it's talking about there is, from the outset, you don't have to try certified mail if you can show that there's nowhere for me to send the mail. But we don't have this case. We actually have an attempted certified mail service. In paragraph 36 of Garrity, it goes on to say, whether the additional search is required will depend on the circumstance of each case. And it was not required in this case, referring to Garrity. McComb's diligent search of the public records in both Guernsey and Cuyahoga County revealed no indication that the sole record holder was deceased and offered no clue as to the identity of any potential successors or assigns. So the issue is, again, it's not bright line. You go to Fonzie, the same thing happened. Now, the key distinction between Fonzie in this case, because the Supreme Court, or the trial court, was relying really on what Fonzie said. The distinction there is, the record where they actually were looking indicated the person lived in a county in Pennsylvania. And the Supreme Court took issue with the fact that there was, quote, no attempt, this is at paragraph, 26, it says, quote, unlike the surface owner in Garrity, here, the surface owners disregarded information about the last known residence of the mineral rights holder and made no attempt to make personal service.
Instead, counsel, I'm sorry. 1 minute left.
Thank you, Your Honor. Instead, the surface owners proceeded straight to notice by publication. So, one, they're not abandoning the case-by-case basis and saying there's a bright line rule. And critically, that analysis says, did you skip, did you try personal service? Certified mail went to the last known public address that was available that the K&R parties had. That was attempted. So unlike in Fonzie, where the person was in Pennsylvania and nothing was done, there was not mail attempted, it was just straight publication, we don't have those facts here. But again, my issue ultimately with the trial court in this case is, it has now enunciated a bright line rule where the Supreme Court of Ohio on 2 occasions has said, no, take it on a case-by-case basis. We believe, based upon the record, that the case-by-case basis will show, based upon the documents that are actually in the record, and admissions by the appellees, that searching Summit County would have got us at the same place. Certified mail at the last known address in Summit County, and notice by publication. And with that, I'll reserve the rest of my time. Thank you, Your Honor.
Counsel,
Yes.
before you sit down, Alex's probate case, the public records in Summit County included his probate case, his last will and testament, and the names and addresses of his next of kin. Is that correct?
I believe, yes, it would have included the next of kin. I know the will, I believe, did as well, correct.
And the property records in Summit County included deeds conveying the 621 Hollow Drive property in the names of Ronald Thomson and Alec Thomson as trustees, as well as a tax mailing address. Is that correct?
Martha, there's in the record, there is a deed into a trust of the property, not the mineral rights, Your Honor. You're talking about the property where the mail was sent to,
Okay, thank you.
not this property.
Thank you, Counsel.
This property was not transferred at any point in time.
Good morning, Your Honors.
One.
My name is Jim Matthews. It's my privilege to be here in front of you today on behalf of the appellees. If I may, I'd like to begin with a few things to get them out of the way. Let's talk first about the admissions that the appellants rely so heavily upon. The admission responses to the set of admissions served by AEP are very narrow, and they're limited to material or information that is immaterial to the analysis under Garrity, Tatum, and the other cases. The 2 admissions they rely upon, 10 and 11, only speak to the following: that there was no documentation in Summit County Recorder's Office evidencing the death of Martha. It was admitted, and it's true, and as we'll discuss here, it's immaterial. Secondly, there were no probate documents in Summit County relating to Martha Thompson's death. That was admitted. It's accurate, also immaterial. The reason it's immaterial is because we need to analyze the actual test that's developed by the Ohio Supreme Court jurisdiction, largely beginning with Garrity. Contrary to what the appellant is suggesting to you, that somehow this court went astray, the trial court went astray, and created some bright line test that had been rejected in Garrity. Trust me, I'm fully aware, since I argued Garrity, I argued for a bright line test in Garrity, and I lost. I did, however, manage to get clearer jurisprudence in Garrity from the Ohio Supreme Court relating to the due diligence inquiry test under the Dormant Mineral Act. What the court fashioned is first an initial test they call the baseline. So your baseline begins with looking at the situs of the property in question. Here there's no dispute, it's Harrison County. So the baseline for whether or not a party trying to rely upon the Dormant Mineral Act is complying with due diligence is what is their search, what did their search consist of in the home situs county. What we have from the record that is absolutely clear, it's documented by the interrogatory answers from the appellants, is that the search here, the due diligence effort, was confined to Harrison County, only to the situs county. The answer is very blunt. The search was confined to the public records of Harrison County, Ohio, because that is where the property at issue is located. Well, the Supreme Court said that's only your baseline. However, the second prong of the test articulated in Garrity was that if a party attempting to rely upon the Dormant Mineral Act to create an abandonment has knowledge, independent of the record or from the record, that they need to look elsewhere, then that's what they need to do. They need to continue their due diligence search elsewhere. We know from Garrity that particular matter, the public record identified a Cuyahoga County address for the reservationist, and there was the effort at certified mail to that address. But more importantly in Garrity, the record documented that those people attempting to use the DMA searched the public record of Cuyahoga County for any other information. And once that was exhausted and there was nothing, the Supreme Court was satisfied that under that set of facts, due diligence was met. Here, we're dealing first with the fact that the second prong of jurisprudence developed by Garrity isn't even met in the first instance. There is no effort to take the search beyond the situs county to the county where they should have looked, Summit, having knowledge, direct knowledge from the record that there was a Summit County address for the reservationists implicated. We know it not only from the interrogatory answer that they knew there was an address in Summit County for the reservationists. We know it because there was the attempt at certified mail to that address. That certified mail was returned with respect to both the 2014 and the 2018 affidavit of abandonment as is invalid and not subject for service. It's my position that at that point in time, it was a legal obligation for the parties trying to use the DMA to look into the Summit County record to see what, if anything, they can develop. Now, my position is that's really the end of the inquiry when they admit to you that they didn't look for anything. And I know it's been briefed. I know it was addressed by the trial court, I think, very thoroughly about the rules. And in fact, the court, relying upon Fonzie and the Toma case, recognized that a reasonable diligence search is mandatory, and that mandate is independent from its results. And there's a reason for that, because we start to get into a little bit of speculation. Well, might the inquiry have found this, or might the inquiry have found that? Might the information that was revealed in the inquiry then been used by the people trying to rely on the DNA? Or maybe they just wouldn't have. Maybe they wouldn't have thought it was important. But I'm going to offer my analysis of what would have happened had they properly expanded their search into Summit County. Had they searched into Summit County, we know that in 2014 and 2018, they would have clearly identified the estate documentation for Alec. The estate documentation is in the record. It very clearly identifies the heirs at that time, in '87, the spouse with an address. That happens to be the same address as the attempted certified mail. I'll get to that in a moment. It also then identifies the children, or appellees, and their respective addresses. In my position, if that were the end of the inquiry, even back in 2014, one couldn't simply assume, well, maybe the mom Martha is still alive, maybe she's deceased, I don't know, and do nothing. You could not have done nothing in due diligence with that state of the record, how they identified that. At a minimum, that would have required them to make further inquiry about the status of Martha. Had they done that, that would have revealed a search of the public record, and we have to remember here the public record is much broader than the recorder's office as suggested in the framing of the AEP, request for admissions. The public record is the public record, things that are maintained publicly. It's very broad, it's not narrow. Had they looked into the status of Martha, they would have found the death certificate for Martha from 1992, I believe it is. Yes, 1992. And interestingly enough, it also identifies an informant there who happens to be Ronald Thomson, a son that would dovetail with the information gleaned from the estate file. It also has an address for Ronald Thomson, which dovetails with that information. Once again, it would have required much more inquiry than just sitting on your hands and being satisfied that you've reviewed the records of the Citus County.
Does it show Martha's address in Summit County?
It does, Judge. It does, Judge. Then, and I believe it was...
And that's where the certified mail was sent?
It was.
Same.
Correct.
Same address, okay.
And I believe it was Judge Sutton then who mentioned that also as part of the record, had there been any effort to review the record of Summit County, they would have found the deed that transferred the property in Uniontown to Ronald W. and Alec as trustees without the same address of the Uniontown location. This, in fact, had the address in Heath, Ohio, which would have dovetailed with the information they would have gleaned from the probate record for Alec.
Counsel, one of the first questions, or the first question I asked the other side was in regard to the summary judgment standard, because we can never forget what our standard review here
Sure,
is.
Judge.
And obviously in summary judgment it's de novo, but it's kind of a weird thing because in a summary judgment proceeding, the court is determining whether due diligence was reasonable or not, which is very fact dependent. So my understanding is you had stipulations that were filed. When you were go ahead.
No, the stipulations were, I think, 2-page. They're very narrow about using discovery generally developed in the case. There's nothing peculiar about them that would dictate one way or the other about due diligence.
So was there an argument, did both sides agree, what I'm getting at, did both sides agree as to what the issues of fact were, that there were no genuine issues of fact as to what actually occurred?
I don't think there's any agreement expressed in the stipulations or otherwise about an agreement to that effect, Your Honor. And respectfully, I just don't think it needs to be present. I would like to reflect on some of my remaining time on the Tatum case. In my mind, this case is virtually indistinguishable from the 7th District Court of Appeals decision in Tatum. In Tatum, interestingly enough, the Citus County happened to also be Harrison County. The Harrison County record had identified a lease that had a Tuscarawas County residential address for the party of that lease who was also the reservationist. Now the inquiry in the first step of the Tatum case, and Tatum, by the way, had the benefit of both Garrity and Fonzie. So that Court of Appeals decision had the benefit, like you do, of both Garrity and Fonzie. What happened there is the inquiry by the parties attempting to utilize the DMA stopped, just like here. There was no effort to search Tuscarawas County for any information relating to the party that had the reservation. Now, interestingly enough, the only slight deviation from the two cases, which I submit as immaterial, is that in the Tatum case, there was no effort by the parties attempting to use the DMA to serve any certified mail notice. They tried to rationalize that by saying, well, it was an old form of address, an RD, rural delivery address, so they couldn't really use it as an address, so they didn't use it. Ultimately, it was irrelevant, immaterial. It meant nothing that they made no effort to do the certified mail. And the reason was because they acknowledged they made no effort to continue the search. It seems as though we want to take the leap to the factual inquiry about, well, what might you have found? And based upon what you found, what might you have done with it? And I submit to you, that's a good inquiry, just so that we collectively and comprehensively are looking at the state of the record. But really, the first question that has to be answered is, did you follow the rules? Yes, the baseline rule was met. You looked at the site as county. But did you have information, or did you glean something from that site as county that gave you information you needed to look elsewhere?
So I want to make sure I understand.
Yeah.
And I'm not asking you these questions about summary judgment just for the heck of it.
No, Judge, I understand.
And
Totally.
here's what a little bit of hang up of mine is.
Sure, Judge.
On summary judgment, was there evidence presented from your client that if they had conducted the search in Summit County, this is what they would have learned?
Well, again, I think the courts are drawing the assumption to undermine the fact that there was no effort to make the search.
I understand your argument.
Yeah.
But that does sound like a bright line.
It,
Well,
It-
let me
it-
finish. Let me finish.
yeah, sure.
That does sound like a bright line in regard to, you're saying it doesn't really matter what the facts of the case were, it only matters if you perform these specific functions, no matter what the
As-
requisite outcome would have been, and that's why I'm getting back to the summary judgment.
As a
So
threshold.
was there something presented on summary judgment that indicated that if they had conducted a search in Summit County of the probate records or whatever, that this is what they would have found, they would in fact have located this information?
No. Answer bluntly to that, the way you phrased it, Judge, I have to acknowledge no. But the record was developed to show, had a reasonable search and inquiry been made of Summit County, this is what information would have been available to a reasonable examiner following due diligence to search the public record broadly, not simply a
So-
part, broadly.
So, I'm sorry for interrupting. I
No, no.
apologize. So the affidavit that was submitted says that if a reasonable search had been conducted, this is what would you have found?
That's the way it's phrased, yes. That a reasonable searcher would have located this.
And there's an affidavit to that extent.
Well, there's an affidavit speaking to what was in the record. I don't think it's necessary. And again, I'm not trying to parse hairs because I understand where you're coming from. But what I'm getting at is a reasonable effort would have had to learn this information. And I'll briefly try to drive home the point from Tatum.
And the affidavit says, here's what you would have found had you done a reasonable record.
That's-
It doesn't have the leap that Judge Carr suggests to that, and due diligence would have been due this, it just said that this is what would have been found with a reasonable.
Yes, and I
Well, that's
appreciate
all I
that
was asking,
clarification.
I'm sorry if I said that incorrectly. All I'm asking is, was there an affidavit that says this is what would have been found?
Yes, and identifying the bits and pieces that we're talking about, correct, including the
Because it
deed.
seemed like you said that was not the case before.
Well, again, I think it's inconceivable for someone to say, had a search been done in 2014, party A, who I don't know or what their skill is or ability, would have identified X. I'm saying the law requires you, who want to rely upon abandonment, to find in the public record, search in the first instance, and then look diligently for the things that are available in the public record. And had you done that, you would have located the probate estate. You would have located the death certificate. You would have located the deed that identifies the trustee transfer and a different address for the trustees of Martha. That's the way I can answer it.
I didn't want to interrupt you, you're running a little about 30 seconds.
Okay, thanks, Judge. And the final point about Tatum is Tatum involved a probate estate having existed in the public record of Tuscarawas County that factually was discussed by the court as being what would have been identified had a party followed the law, followed the jurisprudence that's developed, gone beyond the baseline search and extended it to the county where they had information about a residential location, they would have identified that probate estate. And much like we've had this discussion here, there's no absolute proof they would have found it, but the reasonable search presumes they would have gleaned that information from a diligent search of the public record outside of the sites county.
And your time's up, you may briefly.
Your Honors, I appreciate your time today. I think I got to cover most of the points. Briefly, just to conclude, of course, I would ask that the court examine the state of this record in light of Garrity, Tatum, and particularly the rule developed in Tatum following the Ohio Supreme Court and affirm in this instance.
Thank you.
Appreciate your time, Judge.
what I'm hearing is that there's a bright line test according to the appellee. The appellee says it's 2 parts, it doesn't matter on the second part what you could have found, what you did find, it just matters if you did it or not. Again, the Supreme Court, Gary and Fonzie rejected the bright line. The information about the evidence at summary judgment, Your Honor, no. The only affidavit I'm aware of submitted during summary judgment was the affidavit of Ronald W. Thomson, where he discussed some facts surrounding his mother's death, her condition, and the trust, which the trust, he says here, there's nothing in here about what a title examiner would have said. He doesn't say that. They don't have a title examiner. There's no evidence by affidavit saying this is what you would have found. They do not have any of that in the record. In fact, they say, oh, excuse me.
No, I'm sorry, but the issue is whether this is reasonable due diligence, okay? And all that is very fact dependent. So you're saying they're talking about a 2-part test. Well, not necessarily, because the facts don't warrant a 2-part test. In other words, if you just have the situs of the property, the real property is located in this county, and you have no indication that it has, the owners of that surface or the mineral rights have any connection to any other county, then there wouldn't be any need to do the second step.
Correct, absolutely, no.
But here, the point is, your clients are put on notice that this person did have a connection to Summit County.
Correct, you're absolutely correct. A lot of these cases, I litigate a lot of these cases, they stop at prong 1 because you search in the situs and there's nothing. This is on the prong 2. So under the trial court's decision, the appellee's position, they say, no matter what Summit County would have told us, meaning remember, there's certified mailings. I mean, as you go back and look at Gary, what I talked about, the Supreme Court did not stop at, well, you did the due diligence search, you're good. They focused on, and you did not locate a better address, and they attempted certified mail. Fonzie and Tatum, they did not attempt certified mail. And in Tatum, and we discussed this in the brief, there was actually evidence, based upon reading of that appellate opinion, that the address was still good and there was other information in that county that would have given them a better address. They didn't even try certified. Here, it's different. We haven't attempted certified mail. We don't have any evidence that a title examiner would have found a better address for Martha at the time certified mail was done. Appellees may say
It
that.
almost seems like you're arguing a prejudice. There's just no prejudice that we didn't do it.
Well, I agree. And this is the problem why it's not bright line. If at the end of the day, the evidence shows, okay, if I had done this hypothetical search, I would have got at the same part, meaning I would have attempted certified mail at that address. I would have published notification to them through the newspaper. I end up at the same place. Where's the harm on that level of service? Because they're concerned with service. If Summit County, for instance, had nothing, there was nothing to point to whatsoever, but you knew they were in Summit County, but there's nothing for you, how can we say that we're going to require you to go and do the search? And by the way, if you didn't do that search, even though we know you get to the same point, we're going to a decade later say, sorry, it wasn't good because you did something that wouldn't have changed the facts. And our position is the search of Summit County, based upon the record, would not have changed the level of service.
In your time with counsel, I appreciate the trial court kind of applied this bright line test. Did the trial court make a finding that had your client done the search, they would have found information regarding Martha?
No, the trial court referenced our argument on that point of saying why it was important to look at what Summit County would show, and they said that that doesn't matter under our reading of Fonzie and Gary to that. We're not even looking at that.
Thank you.
Thank you, Your Honors.
And thank you to both. I thank both of you for your presentation on behalf of the court today. The court will take the matter under advisement and solicit a decision in due course. When that decision is released, we mail to you by the quicker court and also be posted on the Ohio Supreme Court website.
Have a good day.
Thank you, Your Honors.